My name is Jadangele Parlo Berry. I'm incarcerated here at Riverbend Maximum Security in Nashville, Tennessee. I was convicted June 25th, 1999 of first-degree murder upon a Negroid girl by the name of Adriane Dickerson. As of July the 10th, 2008, the courts ruled that they have overturned or vacated the sentence due to ineffective assistance of counsel during trial. The counsel at the time was Mickey Gibson and Tracy Jean Cross. Most media have stated that that was the most notorious case ever to be committed in Nashville. It's got most of his publicity from people like Vince Gill and some of the community activists like Earl Jordan and et cetera, et cetera.
When you were initially charged, did you ever think that you would actually be convicted of the crime?
No, I didn't. I mean, when I first was incarcerated or arrested, they had me on totally different accusations. The Adriane Dickerson case didn't come up until 98, and 98 I had already been in prison for almost 2.5 years already. According to them, they had unsealed that case, or what they call it now, it was a cold case, and they determined that they wanted to try me for that case. And they did the trial, and through prosecutorial misconduct and official oppression, they was able to succeed.
Public defender Mickey Gibson was your attorney at the time. How do you feel he handled the case?
First, I have to correct you a little something. Mickey Gibson is not a public defender. He's a court-appointed attorney. He was appointed by the courts because with the public defender's office, I have a conflict of interest. They cannot represent me because they had represented so many individuals that I knew and that knew me, that it caused a conflict where they would not represent this case. So the courts had to go out and do a procedure to where they found a attorney who would work the case pro bono. But his handling of this case is, I describe it as he was subordinating malicious prosecution. He made many and several statements to the news. His distaste towards, the Black Gangsters Disciples, as you know, they say that that's what I was, or that's what I am. He handled this very carelessly, and I can't say he didn't know what he was doing, because most shabby lawyers would have seen this, and there was discussions in this case about going to find Calvin Carter's juvenile records, and they even had some inclination that the private detective that they had hired, Patrick Wells, went and had a telephone conversation with Antoine Kirby concerning the Adriane Dickerson case, and where he had admitted that he didn't believe that I had committed this crime. And of course the courts wouldn't allow that statement to be brought in, but when it was forced into court, that private detective and Mickey Gibson mishandled the evidence to where they didn't have the tape statement. So it was a lot of neglect and intentional misconduct in his representation for this case.
Star witness for the prosecution, then teenage Calvin Carter, you were convicted largely on the strength of his testimony. Would you speak on that?
Uh, as I told my attorneys, I've never met Calvin Carter, don't even know Calvin Carter. According to most media outlets, Calvin Carter says that he was forced to say what he had to say. As far as me being able to tell you what his motives was, I really can't say, but fear. According to his statement on most media outlets, they was talking about them being able to charge him with the crime, and being that he's mentally unstable, they was able to manipulate him in various amount of ways, and therefore he did as he was told.
Davidson County Deputy District Attorney Tom Thurman, lead prosecutor on the case in 1999. Do you believe he suborned perjury?
Yes, I truly believe that he knew, because he's the district attorney. They don't just put anybody there if he's not thorough. Now, why he would put his career in jeopardy, I can't tell you that. But I do assume that his arrogance blinded him in such a way to where he proceeded in this case, in this matter, very maliciously and purposely, with the intent and sole purpose to use a false conviction as a stepping stone to succeed in another case, which is my death penalty case. I don't understand why he would choose me, but what I do know is that there was many instances in the trial transcripts that show that he knew, because, for instance, there was a discovery motion filed by Mickey Gibson concerning Calvin Carter's juvenile records. Mr. Thurman stated to the courts that, hey, the police department has an open policy. That's where you can go down there and research the records. All my attorney had to do was go down to the records. He said that he didn't believe that the Constitution requires him to go and find evidence that is, exculpatory to me. My theory by that is that he knew because he didn't want to go down there and get it.
In his News Channel 5 interview, your attorney says that he actually fought hard for the juvenile records of Calvin Carter to be introduced at trial, but Deputy District Attorney Tom Thurman fought hard to keep it from being presented. Is this true?
Well, according to the transcripts, I'm going completely off the transcripts. Matter of fact, I had read them over the weekend because I'm doing something else that's of a legal concern. Yes, he requested that the district attorney hand over the juvenile records, and Tom Thurman said that he don't have to go get them. That if he wanted them, he'd go down to the police department and get them. And the judge finally said, well, you told Mickey Gibson, well, you should go down there and get them. They never went and got them. But you got to keep in mind, if he was in a juvenile detention center, it was the state who put Calvin Carter in that juvenile detention center.
Also, in his News Channel 5 interview, your attorney implied that the prosecution knew Calvin Carter was incarcerated at the time of the murder, but then turns around and says he does not believe Tom Thurman was suborn perjury. What are your thoughts on that?
Well, I feel like that's just a bunch of legal mumbo jumbo, because for the simple fact, if he knew, then that shows you that his job was to show that he knew. His job was to, let's take for instance the Duke Lacrosse boys in North Carolina. Now, their attorney went and found all types of evidence and different things to be able to show that the allegation that was brought upon them was what you say false. And I guess here in the deeper South, that this good old boy club is basically what you say shielding Mr. Thurman, because if this was, or if I was a person with financial status and was able to pay an attorney, then I think that by now, just like the prosecutor in the Duke Lacrosse case, he would have been disbarred by now for his actions. As recently, he just convicted another person with there was a code case, and in that case he used a prison informant. Now, in Perry Marsh's case, he used a prison informant. Now, some might say that's not my concern, but the public should be worried, because if they find out that these people are lying, it's going to be a lot of families out there who are going to be hurt because they ain't found true closure. They ain't found the truth.
Detective Al Gray, how do you believe he played a part with Calvin Carter and his testimony in court?
Well, circumstantially, he was the inside man, I truly believe, because of his drug use. When they found that drugs in his system, that means that he has a foothold with some of the drug dealers or criminals. Therefore, he has a way to coerce certain witnesses or people that he needs to coerce. I believe that he was the go-to man, his connection to all these criminal activity. As you know, he had criminal activity in his kidneys when he had to take that drug test.
As for the motive behind the crime the prosecutor presented at trial, would you explain in your reasoning why it is ludicrous?
Well, here once again, Mr. Thurman pursued an avenue that was very malicious. First, he painted me as a racist. Then, well, this was his motive. This is what he told the courts. He told the courts that he couldn't try this case without using my gang activity as the motive and intent. This was his whole argument. Now, in order to do that, he did use a lot of stereotypical evidence to present to the jury the stuff that you see in movies. Most times you see gang members, they pulling drive-bys. So he used the drive-by theory because most of the public and most of the people who watch movies, they watch gang members pull drive-bys. when he played on the fears of the citizens of Tennessee in order to gain this conviction. My first theory is that you can ask any what they so-called gang experts or what you call those people who investigate gangs, that the gangster disciples ain't never really got out there and went after someone because of their race. Now they forcing me into a situation to where I have to defend, but it's just the common fact that it don't happen with the gangster disciples like that. And it even with the Bloods and the Crips, it just don't happen about race. Now, I do know that certain organizations or gangs out there that do attack people because of their race, or take the Klan or the Aryans or most supremacists out there, they do it, but never these what they call street gangs.
Deputy District Attorney Tom Thurman hasn't agreed to pursue a new trial or drop the case. Why?
Well, like I mentioned earlier in the interview, he's been using a lot of prison informants lately. It's a possibility that him and some of the administrators in the correctional system have some sort of conspiratorial plan to come about, because that's what he's been working on for a couple of years now. I believe, I truly believe that if my attorneys in which represent me now, if they really mean to really be representatives, that they would have reported Mr. Thurman's misconduct to the proper authorities, to the Board of Professional Responsibility, Katrin Miller, Dan Ham, Mr. Gunn, but it hasn't been done. Now, charges of prosecutorial misconduct should have been also addressed by the courts. Instead of the courts addressing the issues of prosecutorial misconduct due to my actual innocence, leaves it opening to where I can't seek a legal pursuit without that favorable ruling. And there is clear and convincing evidence that there is prosecutorial misconduct, and it was intentional and it was malicious. Earl Jordan, he's a community activist. During my trials and tribulations and the malicious prosecution and the final false conviction, he had a lot to say. Well, now it's time for him to stand up and start talking again, because you have a man who is trampling on your community. Just now, he went out there to on baloney. Now it's time for you to say something, and if he truly is there to help the community, then he needs to say something about this prosecution, this prosecutor, because this prosecutor is just going out there picking up people, citizens. Now, if that's not a threat to your community, then what is? I mean, you could be next.